Hello, welcome to today's webinar. We're going to talk about employment changes that have actually happened this year. The ERB has taken all of the headlines, but there has been some legal changes, and we're also going to talk about how those same issues might be considered in the future, so we'll have one eye out on the ERB. I'm joined today by my fellow partner, Katie, and I'm in charge of putting questions to us, so if you have any questions, please put them in the chat box, and then I will, just before you do your last couple of slides, I will go and have a look at them so we're ready. But thank you for joining us.
Okay, so let's start off with a little recap of legislative changes over the last year. And I should say as well, the slides will be shared with you after the event. So we'll go through these changes in order. Obviously, the big change is the Employment Rights Bill, which we'll cover around in the future, but that's not in place yet. So starting at the top, there was a statutory code on dismissal and re-engagement introduced right at the start of the year. This deals with fire and rehire processes and introduces a code which, if you unreasonably fail to comply with it, could lead to a 25% increase in the compensation awarded, so similar to the ACAS code on disciplinary and grievances that we're all well used to. It's an interesting code in that I think a lot of it is what businesses would be doing anyway and have been doing for years and years. I thought the most interesting and perhaps worrying thing in practice is how to deal with the fact that you may have to dismiss and re-engage, with the code making clear that if at any point dismissal is likely, if staff don't agree to the change that's being proposed, you're meant to make that clear to them and tell them that and consult on that as part of the process. But at another point in the code, it makes clear that it shouldn't be used as a threat to try and get people to agree, and therefore you shouldn't be raising it too early. So I think it remains to be seen in practice where the line is as to when you start discussing that, so that it doesn't create a very defensive and hostile consultation, which I know is why employers are generally reluctant to raise it at an early stage. Important to note that code applies irrespective of numbers, so even if you're making 3 proposed changes, which could lead to dismissal and re-engagement, you still need to comply with that code. Moving on to the ACAS code, advice on neurodiversity at work, it's really just a good resource to point you to. It came out again at the start of this year. I know it's an increasing issue for a number of employer clients that we're dealing with day to day on how to manage neurodiversity at work and create inclusive workplaces. It's got really useful definitions on main neurodivergent conditions. It's got advice on identity first language and how to deal with policies and processes where it may impact people that are neurodivergent in different ways, such as conduct and capability. And then the next one, an actual statutory change, the Neonatal Care Leave and Pay Act came into force in April this year. It's another form of statutory leave. It applies to parents or carers of newborns that require medical treatment within the first 28 days after birth. Medical treatment is quite broadly defined, so it can be in hospitals, at home if you're having follow-up medical appointments, or unfortunately if there's end-of-life care as well. And you get an entitlement to 7 days leave paid at the statutory rate for every 7 continuous days that the child needs that care, up to a maximum of 12 weeks, and it can be taken within the first 6 to 8 weeks after birth. And then it ties in with all of the other family leaves as well, so you could use it after you've been on another period of statutory leave. The Data Use and Access Act 2025 is another piece of legislation that's come into force this year. It's a phased implementation, and we'll talk about that a little bit later. The Competition and Markets Authority Recruitment Guide is another resource just to be aware of. So they've issued guidance on anti-competitive measures that they believe that recruiters and HR teams are entering into perhaps unwittingly sometimes. So I think the key flags from that are around anything that could be construed as wage fixing or no poaching agreements. So they're very clear that while you can have general discussions with recruiters, I know a lot of HR managers will use recruiters to benchmark salaries when they're looking at a new role. And what they've said is you can use recruiters, you can continue to have those discussions, provided they don't tip into anti-competitive measures. And what they mean by that is if you're disclosing or your competitors are disclosing competitively sensitive information that would have the effect of reducing competition in the market. So if you say, well, this is what we pay, we'll all pay the same thing and then it's fine, that's not allowed. If you're generally doing a benchmarking exercise, that is. They've also made very clear that they'll take a strong view on no poaching agreements. So if you have 2 businesses in the same area that agree not to steal each other's staff, again, they view that as anti-competitive and will take appropriate action. And then quickly on to the last 2, so the next one is restrictions on non-disclosures in settlement agreements or other contracts, so it can include an employment contract, and it's a similar rule to the ones currently in place around protected disclosures. So just as you cannot gag an employee who's signing a settlement from disclosing information that would constitute a protected disclosure, whistleblowing, they've now introduced the new guidance around victims of crime with similar rules. So you're not allowed to stop a victim of crime, which is defined broadly to include the actual victim, people that witness the event, and close family members in the event of a serious physical injury, from speaking to regulated people and what they define that as police, lawyers, healthcare professionals, anyone that's involved in treating them. So we think it's probably covered by the normal carve-outs, but it is definitely worth checking the settlement agreements and updating them, because that's in force from tomorrow. Employment Rights Bill obviously is on the cards, and we'll run you through some of that a little bit later. But as you can see, it's primarily a year of development through case law, and we'll talk about some of those judgments, and then in anticipation of the big Employment Rights Bill that's been forecast and currently going through Parliament by the Labour government. So let's move on to some cases.
So we're going to talk about cases, what the judgments are now, but also what might happen to those same cases in a year or 2 years' time when the Employment Rights Bill are. So we've chosen some topical and some fun cases.
Yes, so I think we've steered away from some that have been all over the news. Those have been done already, and tried to find some alternative ones.
So the first one is Price v Accountancy in Bankruptcy. This is an ET decision, and when we talk about employment tribunal decisions, this is the first instance, so they're not binding, they're indicative of their facts. But this is a common scenario where a long-serving, good-performing employee, pre-COVID, was coming into the office 5 days a week. COVID happens and they never return back. What you have is a flexible working request, and flexible working request is and a failure to make reasonable adjustments because Mr. Price was disabled. He had 3 phobias and anxiety. Those phobias included agoraphobia, claustrophobia, and a fear of germs and getting ill. The Accountancy in Bankruptcy was a Scottish government organisation that deals with individuals going into bankruptcy and insolvency. Mr. Price was a computer administrator, and the Accountancy in Bankruptcy relied on 4 grounds to say, look, we want you to come in 2 days a week. They had hybrid working of 3 days a week. They compromised down to 2 days. And this Scottish Employment Tribunal rejected all of the 4 grounds and said it was 100%, it was appropriate that he 100% works at home. So this case, they relied on communications. The Scottish ET said Teams is perfectly adequate. They relied on training, and they said, well, online training is adequate, which is good for us for today, I suppose. They relied on customer-client interaction and productivity and efficiency. So flexible working requests is a really big issue for our clients. We've seen the uptake. Partly that is to do with more diagnosis on neurodiversity and people asking for those amendments. Also, there's a shift from what hybrid working looks like now, and there's definitely a pull to more days in the office. It's like the pandemic never happened. So let's look at all of those factors. Some of us, me, are so sad that we have read every case of flexible working request that's been published in the last 2 years for sure. So this is quite an exceptional case. But I suppose going backwards a little bit, although everybody's got used to hybrid working, it's important to remember that this argument about hybrid working or flexible working, this informal method that employers use, it's not an implied term by custom and practice. That for it to meet that very high legal test of it being very notorious, absolutely dead certain, with legal obligation and right behind it, many individuals don't realise that it's not an implied term by custom and practice. even if you're very comfortable working your 3 to 2 days in the office. And we are seeing employers changing, and partly we are telling them to change, to find their model of work that suits them, for now, but the Employment Rights Bill will make it very difficult for you to amend certain terms. So this is one of the reasons why we have these trends. All the other cases have supported the reasons that an employer has relied on, the very same reasons like, communications, there's the use of tech, there's good judgments which say that tech doesn't replace the fast-paced in-person communication. It doesn't replace team building or training or development days or onboarding people. What the cases do demonstrate is, and is very important where we think there is gaps for clients, is your evidence. So in this Scottish case, this judge did not like them listing 4 random things with very little evidence behind it. They don't like it if you give everybody a great review but don't mention any of these issues, and they don't like it when you have an issue and you don't mention it at that material time. So in this case, there was an issue with one of his training sessions. It had to be redone, but nobody told Paul Mr Price about that. So there's no scope for him to improve that. So generally, it's really important that managers, and we can't remember what we did yesterday, let alone what had happened, but you capture what is good about your working arrangements, both the hybrid, at home, in the office, and also light touch but documented when things could have been done a bit better. The final thing all the cases show is that if you take too long in your flexible working request, there will be some compensation. It's just a week or two's salary, but employers forget there is a timetable on this. The last thing to say for flexible working request is the Employment Rights Bill will be changing this. So it will now be a test of not only do you have to find one of the 8 reasons, but the employer has to show it's reasonable to reject that. So we don't know, that's a new test, but it does seem to us that most of the cases always are involving a protected characteristic. So you have cases to do with disability, for childcare issues, some related to race, they're all in there. And so at the moment, the case laws are already determined on this higher test of objective justification. And we would like to think that there can't be much difference between objective justification and being reasonable.
Thanks. So I've got a completely different topic. So I have the Court of Appeal case of Haycock. So this is binding on courts below it, thankfully, because I think as employer representatives, this is quite a useful, very useful clarification of any AT that I think went a bit rogue. So this was a redundancy case. There were claims for unfair dismissal arising from a redundancy process, and in particular it was found to be a procedurally unfair dismissal because of the extent of consultation and the topics of consultation. And so at EAT, what they had done, and this got lots of hairs racing last year when the EAT judgment came out, they seemed to have introduced an entirely new concept of general workforce consultation that applied irrespective of whether or not the general duty to collectively consult was triggered. So typically, if you have fewer than 20 employees who are at risk of redundancy, you will consult on an individual basis. Normally, you will consult, in broad strokes, you will consult after the business has decided the proposal, the pools, and the selection criteria. That's not always the case, that's generally how it's done. In some cases, the employer will have gone one step further and actually scored the employees and only consult with those that are selected on the basis of those scores. And what the tribunal, so the Employment Appeal Tribunal here found, is that that makes a dismissal unfair, because you should, where no collective consultation obligation is triggered, consult with all of those that might be impacted about everything in the process that could impact the decision to select them. And they said that that should include ordinarily consultation around selection criteria, consultation about how they'll be scored, and consultation around the general pooling even, which is often in dispute, but actually rarely something the employees can influence. And so we then got in a discussion about how we advise employers on that, and no employer wants to put 500 staff at risk to discuss general workplace issues when they know that only 3 or 4 redundancies are going to be made. And so it looked to go far further than the statutory test. So unsurprisingly, it was appealed. The Court of Appeal, I think, have reversed the situation so that it's exactly as we thought it was before. So what they have done is they've confirmed that collective consultation is a distinct principle in law, and that under statute it's been decided that only applies where there are 20 or more redundancies proposed, which is important. It's not for a judge to decide a new statutory principle or a new principle that's not in statute. They said there wasn't any statutes or statutory guidance that required this general workplace consultation, and in any event, the EAT hadn't sufficiently defined it for it to be something that employers could use in practice anyway. However, it wasn't all great news for employers. So while they overturned the decisions and found that actually the dismissals were fair, and that there wasn't this general obligation to consult the whole workforce on those early stages, they did provide some good practice guidance, and they said that actually if you're not collectively consulting with reps about those early decisions that will impact who is selected, it may be appropriate in certain circumstances to consult on an individual basis about those matters. And they said that in principle it is best practice to consult with everyone on an individual basis about things that will impact them, even if you don't do that collectively. So they said that you are, as an employer, at higher risk if you choose to only consult at an advanced stage, because the general principle of a fair redundancy is that it's made at a formative stage where an employer is so open-minded about the outcome, which is much more difficult to demonstrate if you've already scored and are only speaking to the people that you've scored as being selected provisionally. So in terms of tips, and how I think this is in line with the general principles that we would all generally follow. I think where employers do want to score early, we always say, well, it's a risk, you might be able to get around it, and we completely understand the business reasons for it, but it is relevant to the bound of reasonable responses and how fair the process is. So in terms of tip, I think if you can avoid scoring until you have put those at risk and spoken to someone on an individual basis about the criteria, because they may have a valid challenge to it that you haven't thought about, which would change how the scoring was done. That's always better. If you can't or you don't want to, for very valid, normally business reasons, speak to everyone and instead only want to speak to those that score lowest, we would recommend that as a minimum you do speak to them about their scores and speak to them about what the pass mark would have been that they needed to reach to not be selected, to give them a chance to challenge that. And then if all else fails, appeal can save defects, and the Employment Appeal Tribunal and the Court of Appeal both confirm that. So the importance of a rigorous appeal process in those situations, especially where consultation starts at a later stage, is really important to be able to demonstrate a fair process and open-mindedness. So I think carry on as you are, be aware of that risk of early scoring, but we do understand the business pressures that mean that sometimes you do want to do that stage before you sit down with the staff impacted. And that's that one. And I think this one's me as well. So IAD and WL Retail Limited, I think, is just a story of caution around WhatsApp groups and using them for work-related purposes, because they are evidence in a tribunal. What you say in there may not be interpreted as you want it to be and will be used against you. And so IAD was an employee, a young worker, who worked in a cheesecake cafe in central London. And they were ultimately dismissed after complaining that they were too cold at work and that it was impacting their ability to perform their duties. So the context is that the requirement of the co-owners at the cafe was that they kept the doors open all year round, because the data showed that massively increased footfall and competitive market. They wanted as many people in as possible. So in the WhatsApp group, this employee complained consistently about being too cold at work once the temperature started dropping. They said that even with thermals and 3 layers on, it was impacting their ability to do work, and asked whether or not either the door could be closed or a heater provided. They were told no by the co-owners in response in the WhatsApp group. The co-owners then said that previously staff had a heater, forgot to turn it off overnight, and the cafe almost burned down, or a fire might have been started. So this employee responded and said, none of the staff at the cafe now were here when that incident happened, so we shouldn't be blamed for that. She recorded the temperature in the WhatsApp group saying it was 12 degrees, and then the next day or a few days afterwards she also reported that she'd spoken with a customer in the cafe, and that customer had told her that it was illegal to be required to work in conditions that were under 16 degrees. So all of that was in the WhatsApp group chat. What then happened very shortly after that last message around the legal obligation around the minimum temperature is that she was called into meetings, she was criticised for consistently being late, told that her constant complaints about management were an issue, and then her hours dropped even though they were hiring more staff at the time, so there wasn't really any obvious reason to drop her hours. And then a few months after that, in April the following year, she was dismissed in writing. They made attempts to arrange a disciplinary hearing 3 or 4 times, but she couldn't attend because they were arranged outside of her working hours. So they went ahead in writing and dismissed her. And a tribunal found in her favour, so they concluded that those group WhatsApp messages together constituted protected disclosures. In particular, they set out allegations around health and safety. They found that there was a public interest because matters of health and safety will generally be, and she was clear she was speaking on behalf of the whole workforce rather than just herself. And they also found causatively, given the timing and the fact that they seemed to expressly acknowledge it was because she was complaining about management, unsurprisingly they found that there was a link between those protected disclosures and the detriments pre-dismissal, so the reduction in hours, the being told that she was late when actually the evidence was that all of the staff were regularly late and no one else was being sanctioned for it, and then subsequent dismissal were all because of the protected disclosures she made. So she was awarded £22,000, which was a combination of lost earnings, wrongful dismissal for her notice because it was a summary dismissal, a little bit of injury to feelings, and pension payments that weren't made either. So yeah, I think just be aware of what's in WhatsApp group chats, and if there are any issues, it's always best to not sever any causative link, I would say, between protected disclosures and any other action you're taking. And then the next case we can run through really quickly, because it was more just this case caught lots of headlines because the award was over £1 million, which is incredibly unusual in the employment tribunal. So in the case of Hibbert, Chief Constable of Thames Valley Police, a police sergeant was awarded this massive amount of over £1 million following a discriminatory dismissal and a discrimination arising from successful claim. And in brief, the facts were that she joined as a cadet at the age of 16. She'd worked her way up, had several promotions, and was ultimately dismissed while she was off sick. And the facts around that were that when she was off sick, she had outside interests, which was approved by the occupational health specialist. They told her to make sure she had outside interests because her job was incredibly stressful. She was working with vulnerable young people in relation to exploitation. So that was encouraged medically to help her rest and recuperate. While she was off sick, Thames Valley Police removed that right. So they authorise outside activities, they removed the authorisation. And as a result of that, Ms Hibbert's mental health deteriorated significantly. She was then subjected to threatened disciplinary action because they found that, or they alleged that she was continuing her outside activities despite the authorisation having been removed, and she then resigned in response to that and brought this claim. The tribunal found that the removal of the authorisation was because she was off sick, and therefore found it was linked to her mental health conditions, which they concluded were a disability, and they found that that decision was an irreparable breach of trust and confidence, which gave rise to the discriminatory dismissal. Compensation looks significant, but it is worth flagging that actually there was only £8,000 awarded for injury to feelings. So the vast majority of this 1.1 million was for her pension loss because she was in a very generous pension scheme. So I think over half was the pension, and a lot of the extra bit was grossed up tax amounts to make sure that she got the full amount, because they concluded, I think rightly, that she wouldn't have left before retirement if this hadn't happened, and that she would have got at least one more promotion. So the figure looks huge, but I think vast majority of that is pension, only 8,000 injury to feelings. So I think that's the thing that's worth keeping an eye on. So it's unlikely you'll be in a similar situation.
Oh, this is my one. So this is to do, it's a positive one for employers because it's an employer that met the threshold that they took all reasonable steps to defence to a claim of discrimination where the discrimination was admitted. So in this case, it was held that the trust had done enough measures. So there was a disagreement between a union rep and one of his colleagues who was in the union, and he used racist language, which was admitted. But the tribunal held that the trust had put training in their induction, only a small part, but it was part of their values, and they referred to it as the the proud values. They had mandatory training, which was repeated every 3 years. And luckily, in this case, it happened just a few days before, so it should have been really in their mind's eye. And that it was on notices around the trust, and it also formed a part of the annual review. There was specific discussion about the values and the respect. So interestingly, the EAT, so it's a by, uses its words all reasonable steps, and that will be the new law post the ERB on sexual harassment, that an employer has to prove all reasonable steps. Now clearly this was decided on facts which are a few years out. In order for employers to meet that same requirement now, I think you probably have to have a risk assessment as stipulated by the Equalities and Human Rights Commission, and go through that assessment, which really covers out how are you preventing it, the training, how you report how a complaint's dealt. It's got there's some quite good guidance by the Commission, particularly for certain sectors like hospitality. What I would also point out though is that as the law is changing, so there won't be confidentiality on discrimination, so people will be able to openly speak about what's happened to them. One of the concepts an employer should be developing is if you give robust enough training, you can actually pass liability on to the individuals that have elected to behave in such a manner. And I think we'll see more of a shift, as you have to do training anyway, to that model, which is more of an American model.
And then I think the final case is me again. So this is a gross misconduct dismissal, and again it's just harping on about the importance of a good process and the importance of a good appeal process if there are defects initially. So Mr. Naffo was dismissed for gross misconduct relating to allegations around inappropriate comments of a sexual nature. The allegations were that he made several inappropriate comments. As part of the process, he accepted that he'd made one of those comments and denied the rest of them quite robustly throughout, at all stages, denied that he'd made them. The comment that he accepts he made was a question about how young is the youngest a 40-year-old man can go with, was the comment that he accepted he made. And then he provided some context to try and justify why that comment was appropriate to make to a younger female co-worker. The younger female co-worker reported the conduct and said that the comments made her feel vulnerable and ill, and that triggered a process. So at investigation stage, he'd acknowledged he'd made this one comment. At investigation stage, crucially, I think, and I think this is where the whole case fell down for Barclays, the complainant had said that the comments were made, she remembers them all, but actually she does zone in and out of conversations with Mr. Naffo because of a medical condition she's had, with the implication being that her recollection may not have been as strong as it might be. So petition was made, there was a disciplinary case to answer. It was then handed over to a disciplinary officer. That disciplinary officer didn't undertake any further questioning or investigations of their own, and of course they're not always legally obliged to, but arguably when you've got the person that's being subject to disciplinary action being adamant that they didn't say anything, but accepting they made one comment, and the complainant acknowledging that a medical condition means that they don't always remember everything that's said to them, this might have been a case where the disciplinary officer might have wanted to challenge a little bit more that evidence or see if there was any other objective evidence that they could gather to corroborate one version or the other. They didn't do that. They relied solely on the investigatory statements. The process took quite a long time, so it was 2 months before an outcome was issued. And again, another fatal error of this process, the outcome letter referred to 2 entirely new allegations that hadn't been put to Mr. Naffo, and therefore he hadn't had a chance to defend himself or respond to them at all. So he was dismissed summarily. He appealed that decision, and the appeal unfortunately didn't remedy any of those earlier defects. So the appeal officer again chose not to carry out any clarifications from the original witness statements, didn't undertake any other interviews, and ultimately determined that the original decision was valid. The appeal officer seemed to rely a lot on his admission, on the complainant's allegations, but also on his approach at appeals. So he was quite defensive and frustrated At appeal stage, he said, well, that's because you keep asking me the same questions and you're not going to get a different answer. I didn't make the comments, so I can't tell you why I made them or what I meant by them. And so they relied on that frustration as evidence of guilt. He obviously says the opposite. And so it went to tribunal and it was found to be an unfair dismissal, I think probably unsurprisingly given the issues in the process. And I think what I found most important here was the tribunal didn't let Barclays off the hook on the basis that he'd accepted some faults and on the basis that a perfect process would have achieved the same outcome. So they went as far as to say, well, actually, we don't know, because this process was so defective. We don't know that a fair process would have led to dismissal here, because you aren't clear in your outcome letter that that one allegation was sufficient to justify a gross misconduct dismissal if you're relying them all together. And we don't know if you'd gone back to the complainant whether or not they would have given the same version of events or whether or not their memory would have changed given that they had a known medical condition. And so in those circumstances, you can't have a 100% reduction in the compensation because you might have not been dismissed had you followed a proper process. So instead, they gave 15% contributory fault reduction to the compensation because of the admission around the one allegation, and then a 50% poll key. So the tribunal decided that there was only a 50% chance that he would have been dismissed fairly had a proper process been followed. So I think that just stresses the importance of if the appeal officer had gone back and spoken to the complainant and got a consistent version of events, I think that poll key reduction would have been much higher. But they didn't remedy those earlier issues, unfortunately. So it's just one to be aware of that appeals can solve, they can render a dismissal that is unfair fair if you do what you need to do.
Okay, so now we're going to look what's coming up and how that may impact you. So let's follow this yellow brick road of the Employment Rights Bill. So, hot off the press, we're in conference season, but we know on the 28th of October, the bill will be coming back and it's likely to be passed then. So it means that within 2 months, so by the 1st of January, I had to work it out in my head there, 1st of January, these changes will be in effect, and this might be a road to utter discontentment, I'm not sure. So what we will have is the majority of the Trade Unions Act will be repealed. If you are unionised, this is quite significant because it makes it far more easier for the union to go out on strike. Looking at the press and conference, I don't think anybody's happy. So employers are saying that the Labour government is not listening to them, and there's discontent because people feel that their quality of life is impacted or not positively. So the repeal will mean that at the moment, if a union wants to go on take industrial action, they have to go to ballot, they have to have at least a 50% turnout and 40% positive approval of that strike. Those are thresholds. The repeal will mean that there will be a ballot, but it will be just a simple majority of those who can be bothered to vote. I think common sense needs to prevail. I don't think a union will want to go on strike if it's only a small majority. That weakens their position and actually creates some issues. But it is an issue and more of a card. There'll be a simplification of the industrial action notices, ballot notices. So at the moment, they have to stipulate the category of employees that have voted and whether they're going for industrial action, i.e. strike, or short of industrial action, like no overtimes and things like that. That's helpful to an employer because they can see who's balloted and they might want to do some of their contingency planning around how they're going to cope with the strike. And then there'll be more protections against dismissal for taking industrial action. The cases clearly show that that's done in very rare, extreme circumstances when there has been something so obviously egregious that's happened in the strike action that warrants dismissal. Then we have a few months later in the sunny spring, I hope, we will have the following changes, which is electronic balloting for industrial action. I mean, this should have come in ages ago, but at the moment you have about 6 weeks by the time you get all the ballots and everything in to plan for industrial action and obviously have discussions with the unions and get to the nub of issues. That's going to be shortened right down. And we're going to have the doubling of the maximum penalty for collective consultation, going from 90 to 180 days. Now, this is a penalty award when you don't do your HR1 form, you don't collectively consult. It's to the case you're going, it's already predetermined. So this idea that you've got to collectively consult, and it is a fine. You get told off, it's an example. That's why it's a gross award. The disclosure of sexual harassment will be a qualifying protected disclosure. Harassment is already a breach of a legal obligation, so we would say it would fall in there, but it's making it very clear. There'll be day one rights, which I don't think anybody has issues for, which is unpaid parental leave and the paid 2 weeks statutory paternity leave. There'll be this establishment of the Fair Work Agency, which will deal with national minimum wage, rights to work or group, but they'll just starting to get going. That's what they'll be established. And then there'll be the removal of the earning limits for statutory sick pay and waiting days, which impacts the lowest paid employees. And then there will be simplification of the trade union recognition process, which is again unions showing that they have a simple majority of those that are voted in your business unit. So whilst there's been a delay to the ERB, we think it's going to have all assent beginning of November. This will mean that there'll be no changes to the implementation plan or your period in which to consult, and there'll be consultation happening. I think it's remarkable that this is a piece of legislation that has hardly been amended. The House of Lords, unless it was already agreed with the government, were completely rejected. So this government is using its majority to shoehorn legislation which is yet not developed. And so the voice of businesses by your various organisations really does need to take advantage of this period whilst already working on your ERB plans so that you're ready to go, because things aren't likely to change.
And then you're just moving on to the ones that have been pushed back. So we now have confirmation that the changes on the slide now won't come in until October 2026. And so the key one, I think, going back to the case we were discussing on the Code of Practice right at the start, is the fire and hire limitations. So on Monica's point around very few amendments being made to the Employment Rights Bill as originally drafted, the House of Lords put in some quite significant amendments to this, which I think business would have been largely happy with and which seemed very sensible. And they've all been kicked back by the House of Commons. And so as it stands, fire and rehire will be incredibly limited once the Employment Right Bill comes in, and specifically it will be an automatically unfair dismissal if any employee is dismissed because they did not agree to a change to their contractual terms. That's any contractual change, which could in theory include a change to their job title, or if the office moves 2 miles down the road, anything. Change of line manager if you use a name rather than a job title for the line manager. So I think that's quite a worrying development. My view is that you should all be looking at your contracts now and trying to make the most of flexibility clauses and mobility clauses. If there's anything that can be made more generic, you should do so within the confines of the Section 1 requirements. And if going back to the point around place of work as well, if you want an informal hybrid policy, you need to make sure your contracts say that, because if there is a contractual right to work from home for some or all of the week, you will be stuck with that once these changes come in. And that again, there's the doubling of the protective award around that as well. That's true even if you intend to re-engage immediately afterwards, and even if the change isn't detrimental, that isn't a requirement of the automatically unfair dismissal. So I think it could be used by lots of employers and unions to negotiate other benefits in exchange for their agreement to a change to their terms. And then the other ones I think are more straightforward. So there will be a new, we think, Section 1 requirement to inform workers of their right to join a trade union. So essentially you're going to be required as employers to advertise for the unions in their contractual paperwork. We're not sure yet whether that's going to be in the particulars itself or in a separate document. That will be followed up after consultation in separate guidelines. But it's coming in and you will have to do it. We're not sure if it's going to be a repeated duty or if it's a one-off. So all of that is yet to be confirmed. Alongside that, there are increased access rights for unions, and that's in your workplace and digitally. So you will be expected to go through another statutory process similar to statutory recognition. You don't have to be a recognised union to have a right of access to a workplace. That's a really important point to be aware of. So even if they're not recognised, they can apply to have a right of access. If you don't agree, that would then go to the CAC to determine, and there's likely to be a default position that you fall back on, like there is with statutory recognition. With the digital access, we're not clear yet if that's a digital platform that you'll be required to set up for them, or if it's the right for them to send emails out on your systems. So that again remains to be seen. More increased protections for union reps against detriments and dismissal for undertaking their trade union activities, including a right to paid time off. And then Monica's already touched on this. So currently there's this reasonable steps to prevent sexual harassment. That's going to be changed to all reasonable steps. And given how high a bar that looks to be, the government have conceded that they will work on issuing a code of practice and what they think all reasonable steps is, so that at least employers will have a tick list that they can go through, although it's likely to be sector specific and industry specific anyway. Third party harassment is a new duty for employers to prevent harassment of their staff by any third parties. So that's going to impact some sectors more than others. I think most obviously hospitality, where you've got people working in bars, and you now have a duty to protect your staff against what everyone in that bar is doing, or hotel or similar. And then finally, the increase to the time limits for tribunal claims from 3 to 6 months is going to come in from October 2026. There's no announcement around additional funding for ACAS or the tribunal system to deal with what they think is going to be a 15% increase in claims, but we'll see. And then the other key changes, including the day one unfair dismissal right, which was their manifesto pledge, has been pushed back to 2027, and no specific date at all for the implementation of that now. And then moving on to something completely different. So AI and data protection developments. Obviously, this is a really hot topic. We come across it more in both advising employers in recruitment and in tribunals. And so we've been starting to have a look at this and how best to help clients manage it, but also what the change in legislation is around this. So with recruitment, for example, the stats now are that 1 in 2 candidates is using AI to either write their CV for them or even answer application questions. And so you as employers and HR departments need to be undertaking your own due diligence to learn to identify that, or to learn how you need to adjust your processes to defeat that if it is something you want to defeat, so that you know the candidate you're getting is actually the candidate that you're seeing on the paper forms. And so alongside that, given the rise of AI, and data protection concerns around that, because whatever you put into some of these AI tools, they store them forever. And so if you as recruiters are using AI tools, or you in HR are using AI tools, you need to be really careful about what data you're putting in there as well, whether or not that contains personal data, and whether you're happy that that's adequately protected. And so alongside that, we have the new Data Use and Access Act. Those provisions are becoming active from June this year until June next year. And some of the biggest changes are on the slide, so very quickly running through those. There's around relaxing the existing rules and automated decision making. So you are going to be able to now just rely on the normal, any other data protection justifications, and legitimate business reasons, a requirement around fulfilling the contract, etc. It's going to be enshrined in law now, rather than it just being best practice, that organisations are allowed to try and limit the scope of a DSAR and clarify the scope of a DSAR before the time limit starts to run. Alongside that, it's also clear that individuals do not have to limit the scope of their DSAR. It's also going to change so that in law, rather than it being ICO guidance only, it's going to be a requirement employers only conduct reasonable and proportionate searches, which will hopefully help you manage those really unwieldy DSARs of employees saying, I want everything from the last 100 years. There are new rules around protection of children's data. So if you have, as part of your business, any apps or services that are likely to be appealing to children, even if they're not the target audience, there are added conditions that you need to follow to make sure that you're complying with laws around that. And then finally, complaints processes on how people can complain if they're not happy on how you're dealing with personal data are being introduced as well, just to make sure that your complaints policy is really transparent and clear. And then very quickly on these, the ICO plans to introduce a statutory code of practice on AI and automated decision making. So we'll see what that says in due course. And then the EU have introduced an AI Act, which is going to be fully implemented by August next year. Of course, we're no longer in the EU, so it's not directly relevant. But if you have cross-border jurisdictions, for your business, you're likely to have to comply with those obligations anyway. And the principle of that is in essence that AI is going to be categorised by the risk, and unacceptable risk category AI is going to be banned. So that's something you'll need to be on top of.
So this is our last slide, I think. So if you've got any questions, I've got some coming in now, but if you put them in, we'll try and get through them. So this is a case which is regarding the use of artificial intelligence by employees and claimants in employment tribunal case. Now we are seeing a lot of AI use, and it's only as good as the information you put in it and the what comes out of it. So in this particular case, she had suffered sexual harassment, and she had used a variety of AIs to produce her statement for tribunal. And what the court said, that's permissible. But what they did do is saying that we retain the right to consider that use, and that will weigh in whether we find an individual is credible. They found her very credible because I think the facts spoke for themselves. So it's merely putting more eloquently in that case what had happened. What we are seeing is employees for grievances putting in lots of rhetoric, lots of big words and sounding. You look at it and think, oh, this is bad, but there's not much facts behind it. And sometimes the law is bizarre.
Entirely made up.
Yeah,
I think in some cases.
Absolutely. So we would be saying to employers that you can ask people not to use AI tools, just to say, please simply give us your facts. It's our role to see what that means, what breach that has been, just explaining your own words. Certainly for grievances and disciplinaries, that's appropriate. You may want to use an AI detector, but they have to be used with caution, but they're a good indication. And there is some tribunal guidance on AI, and we're seeing lots of claimants getting short, sharp shrift with using AI, and actually getting strikeout deposits because they have misused AI and therefore presented their facts and the list of issues inappropriately. So I think that's it, and I will just see if we've got any questions. So we have one question. So with this test of all reasonable measures for avoiding discrimination, does that mean if there's one issue that the employer hasn't done, means that they will fail on this test?
Well, I think that's a question yet to be answered. So I think in theory, yes, but I'm hoping now the government have conceded they're going to issue this guidance on what they consider all reasonable steps to be, there might be more wiggle room. But that's certainly the fear, because I think if the test is all reasonable steps and the claimant is able to identify a step that they say is reasonable that you didn't take, it must be arguable then. And then I guess it's for the tribunal, same as with the reasonable adjustments argument, actually was it reasonable in the circumstances or not? So I think it is a worry.
I think that's right. I think I have read somewhere that there's been this idea that the all is quite threatening, but the reasonable balances it out. But we wait to see what that means. I suppose one of our last parting shots is it is conference season. It is also Christmas parties coming up. So please get your comms out to your staff, to the conference providers, to entertainers that might be.
Contractors,
anyone that's there, just so that you can at least tick that part of the risk assessment off. And historically, we've always been relatively busy in January for all the wrong reasons. So perhaps that could happen at the moment. I don't think there's any further, let me just check. No, if there's any further questions, you can always email us, and thank you for attending, and we will send out the slides.